Collateral source rule. Damages, collateral source rule, generally stated, the successful tort plaintiff's damages award is not going to be reduced by the value of benefits that the plaintiff has received from sources that are unrelated to the defendants. That's the general rule. So what does it look like in practice? And I will say that before we look at the North Carolina statute, what its framework is there's been some criticism of this rule that says that this is a method that allows plaintiffs to recover twice by what they may have had their own insurance for, and also recovery from a defendant who was a tortfeasor to them. And it's just kind of a public policy issue as to where you fall down on that. North Carolina put a new statute in place in 2011. Actions commenced after October 1 take evidence of actual payment rather than what is a billed amount. Generally, the place where this comes up most common is in medical expenses. You go to the doctor, their standard customary charge for this visit or procedure or treatment is $100. They bill your insurance. The insurance pays $25. You have a copay of $15. So it's actually cost $40 for this $100 bill from the doctor. In South Carolina, you're going to find that $100 is what gets to go in front of the jury as what the cost of that was. Under this new statute in North Carolina, the $40 is part of what's going to get to go in front of the jury is what was actually expended, what the actual value. So if the plaintiff gets essentially a discount on something, then that discount counts forever. In other jurisdictions like South Carolina, where they follow the reasonable value rule, that discount, say from the doctor bill, is not necessarily going to be something what the jury knows. What the jury is going to know is that the hospital bills or the medical bills or the repair bills, what the total was, what the big number is. They're not going to know what was discounted or cut off or otherwise paid. It's also interesting to note in South Carolina that there is a decision that talks about the proper measure of damages and the reasonable value, that there can be no instruction about that this money is not going to be subject to income taxes. It came up, somebody wanted to say that, if they get this money, it's not going to be taxed as income to them, and so we don't want the jury thinking, well, we've got to give them more because they're going to have to pay part of it in taxes. Well, that's no talking about that in South Carolina, at least. Look at Florida. Florida's rule basically is the award is going to be reduced by the amount paid for the benefit of the plaintiff. Florida's got a very in-depth collateral source indemnity statute, which I won't keep you from lunch by reading that to you. But it's not quite as interesting as the federal pleading cases I mentioned earlier about Twombly and Iqbal. So if you really can't go to sleep after reading those, you may read some of these Florida statutes as well. Federal courts, I did want to mention collateral source rule in a recovery under environmental CERCLA action. What the court decided was that because the party had received a recovery that had paid for costs of damages that they had been suffered, that under the statute, the 10th Circuit says that they're not going to be allowed to recover basically a second recovery from that. And so